In today's episode, I'm going to walk you through the estate planning documents 101 that we always go through with people to ensure that they have the right documents in place. And so by the end of this video, you're going to know exactly what you're going to be needing to have in place, what documents you're going to need to have in place, and stay till the end to make sure you don't miss anything, because I wouldn't want you to drop off halfway through and only have half an estate plan. So let's make sure we have everything in place the right way.
Joe knows taxes.
Joe knows the market.
Joe knows Social Security.
Joe knows income planning.
Joe knows pickleball? No.
This is Joe Knows Retirement.
Now, when it comes to estate planning documents, we just see too often that not enough people have estate planning documents in place. And what we see is that, maybe they say, I'll get it done eventually. I'll get it done. They keep procrastinating. And then they come to a time they're like, I better get this done now, because if I don't get it done now, I'm never going to get it done. And so that's our encouragement here, is making sure that you take that next step after watching this video to ensure you have it in place. And maybe you already have it in place, but it hasn't been updated. Have you looked at it over the last 3 to 5 years? And if not, I would challenge you to make sure that you take that step to make sure you have everything that you need. So to start off today's video, let's just first understand the importance of these documents. As we all know, everyone needs an estate plan who is 18 or up. Everyone needs some sort of documents in place. Maybe not everything we talk about today, but they're going to need basic documents, and we're going to cover the basic documents here soon. And then what we see is that only 30% of people die with an estate plan in place, which means that there's 70% of people that are left without any planning. And so we want to encourage that 30% to go up a little bit. Hopefully with all the views and likes we'll get from this video, and all of you sharing this video, that we'll be able to reach that 30%, maybe up to 35 or 40. With how many lives this video could touch is ultimately our goal. But seriously, this is something we want to take seriously. We're all going to pass away. One spouse is going to pass away first. Let's make sure we have everything in order that we need to, because we can't do it when it's too late, is ultimately what we tell people. So let's first start off by talking about the basic documents that you'll be able to, that you need. And so we're going to talk through them all on the screen right here: the last will and testament, financial power of attorney, healthcare power of attorney, the living will. We're going to talk about a HIPAA authorization form. We're going to talk about TOD, which is a transfer on death designation for real estate, vehicles, and other assets you may have. And then we're going to talk about just probate avoidance in general, making sure you have the right beneficiaries in place. So let's start off the top there. Let's talk about the last will and testament. So with the last will, this is the most misunderstood of all the documents from what we see, because most people think that this avoids probate. That is actually not true. This is not avoid probate. It actually tells the assets that do go to probate of where those assets go from there, is what this document does. It does also, tell who the executor is going to be and list out some of the details that you want when you're no longer living. So that's something to keep in mind with this. And just keep in mind, since this does not avoid probate, you're still going to have to pay that 4 to 7% probate cost if you do go to probate, typically, is what we see. And so let's take a moment just to explain what probate is. I'm going to reference probate a few times during this video, because at the end of the day, a lot of people get estate planning documents and specific documents in place to avoid probate. And if you've ever been through probate, or you know about probate, it's very timely. It takes a long time to actually get access to the assets that you're entitled to if you're the beneficiary. And it's also very costly, as I just shared. That 4 to 7% is the average cost. And so you can easily avoid that. And so we're going to talk you through how to do that by making sure you have the legal documents in place to do so. But basically what probate is that there's no beneficiary title on the assets. There's no understanding of where that money goes. Well, then it's going to go to the probate courts for them to decide where your money goes. And so we ultimately want to, obviously avoid it for that reason too. We want to make sure the money goes where you want it to go. Don't let the courts decide that. Let's decide it ourselves for what you truly want. The next documents that we're going to talk about are the financial power of attorney and the healthcare power of attorney. So let's start with the financial power of attorney. Both are going to be very similar, just cover different things. So these are the two most important documents, in my opinion, because this is going to allow someone to help you make decisions when you no longer can. And the other reason why this is important to have in place is because typically you want this in place when it's too late. And so we need to make sure that we have this in place before we can't make decisions, not after we can't make decisions. Ultimately is the idea. And so what this financial power of attorney does is this is going to allow someone to make financial decisions on your behalf, paying the bills and making sure that all those decisions get made if you no longer can do that for yourself. And something to really consider here is making sure that POA actually signs correctly on your behalf, because we've actually seen that attorneys have not made sure that that's clear, and that actually can lead to some issues. And we've actually seen where someone was held personally liable for not being able to have that signed correctly for that POA. So just ensure you're actually doing it correctly. And that's why another reason with all these documents, we recommend you work with an estate planning attorney who knows what they're doing, someone you trust. You can do all this on your own, but we just would not recommend it. I would never do that on my own, because these documents are way too important and there's way too much to know outside of this 101 class I'm giving you right now. And so you just want to make sure you're not missing anything is what I would advise. Now, the other power of attorney, as I mentioned, is a healthcare power of attorney. This is going to be the one to make healthcare decisions for you when you no longer can. And so with this healthcare power of attorney, if you're in a coma or maybe you're in a vegetative state, this is the document that's going to allow them to step in and make those decisions, such as pulling the plug or making any healthcare decisions that you just would not be able to make for yourself, but actually what you would want for yourself is ultimately the idea. One case that we always think about here with the healthcare power of attorney is the Terry Schiavo case, which you've probably heard about or familiar with. And what happened with here is that they wanted to remove the feeding tube in 1998, but because there's no documents, because there's no healthcare power of attorney, they weren't able to do so. It had to go through courts. They had to argue about it. Family members had to argue about it to ensure that this is what she wanted. And it actually didn't get resolved until 2005. And so she had feeding tubes from 1998 to 2005 without any resolve is ultimately the idea, which could have easily gotten taken care of by just having a healthcare power of attorney. And so that's just a story to explain how important this is, and just have control of what you want happening with your healthcare at that point. So the next document is the living will, which goes together with the healthcare power of attorney there. And this document is definitely confused with that last will and testament, right? They both have the name will in it. So this is different than that. Living will has to do with your healthcare, and this is going to be actually your choices that you want to see done for that healthcare power of attorney to enact. And so this is why it's going to make that person's job so much easier, because they're going to know exactly what you want. They're not going to have to make the decisions of what they would want. They're going to be able to follow that document to follow the decisions that you want. And again, with Terry Schiavo, if she would have had this in place, it would have made that healthcare power of attorney's job really easy to make sure that got put in place the way she wanted it to. The next form we want to talk about is what's called a HIPAA authorization form. And some of you are probably familiar. Maybe you've sent your kids off to college and you probably started to realize, oh, wait, I need a HIPAA authorization, because if they go to the doctor and something happens, the doctor can't tell me unless I have this form in place. And so that is ultimately the idea of this form. That's why you want to get it in place. And just understand that anyone 18 or older, or even a family member, a spouse, cannot receive guidance unless this form is in place. And so some of you are probably thinking, well, I've been at a doctor's office before and my spouse was there and they said whatever. Well, that could be true. They can do that. But you could also assume, or if they have been sued, they're probably going to be a lot more careful about doing that, is ultimately the idea. So why are we going to let it up to a doctor to decide if they can share information with the spouse or not? Just get this simple form in place, make sure everything's good, but also family members making sure they have this on file. Maybe it's your kids that you want to have know what's going on, who's ever important to you. Definitely want to make sure you have this in place. And also keep in mind, with the healthcare power of attorney, only one person can be put on this document. So if there's others, this is the place to do so. And this can be used not only for speaking to doctors, but also speaking to health insurance companies to ensure that you're getting everything done in the right way if that other person is not able to. And as we all know, healthcare is a very private and very protected scenario, so that's why these documents are going to be so important, but also mostly followed in the correct way by the doctors, because, again, they don't want to get sued, and they want to make sure they do it the right way by also protecting you. The next document we want to talk about is transfer on death. It's a TOD, and we're going to talk about it for real estate, vehicles, and other assets that you may have. And so the way this works is that this is basically going to be a beneficiary designation form for those assets. And so if you do not have a transfer on death or a TOD on your house, I would definitely recommend you look into doing so, because if you don't, then that could go to probate if you don't have that titled the correct way. And we see a lot of people who do not have their assets titled in this manner. And so it's really easy to do. You just take the paperwork over to the county, fill out the paperwork, let them do that. They'll send you some information back to confirm it's done, is what we'd recommend there. And again, we want to avoid that 4 to 7% value. For example, if your house is $500,000 and that goes to probate, that's thousands of dollars that you would have to pay for court fees and all those fees combined that you don't have to by just simply having a simple document in place. And so that's what we want to avoid. We want to make it very easy for your beneficiaries to receive your assets, and this is one way that you can do it. And what we see is real estate is one of the most common assets that end up in probate. And so that's why, hey, we can easily avoid it again just with this document. And then the last thing that we want to talk about here with the basic documents that we want to recommend everyone have is what we call a probate avoidance guide. Now, this is going to detail out many things. At our office, we have an attorney that meets with our clients. And so that attorney has all this structured out to making sure that everything gets done the right way. He's done it hundreds of times, but also making sure that he holds that client accountable to make sure everything gets titled the right way, to make sure that, you know, the car and the real estate that we just talked about, the jewelry, whatever it is getting done the right way. And you also have to understand that you need beneficiary designations for retirement accounts. So 401ks, IRAs, you want to make sure that those have beneficiaries. And if those do, those will simply avoid probate. You don't need any TOD on those or anything. You just need a simple beneficiary on file for those. Also for bank accounts, you want to have something called a POD, which is payable on death, which is going to be important for those documents as well. So let's transition here, and let's talk about some trust. So let's talk about the pros and cons of trust, who needs a trust, who doesn't need a trust, should you get a trust? And I'll first start off the conversation by saying that only about half of our clients actually end up getting trust. So if you've probably been told, if you've ever seen an attorney or you've ever gone to a workshop by an attorney, they've probably pushed trust really hard. And you got to remember that they are going to get compensated more for trust. And you have to understand too that trusts are great documents. I mean, I think that the right people should have trust, but just understand you may not need to pay that money for a trust by just doing those basic documents we talked about, depending on your situation. So we're going to help you try to walk through to see if this trust is actually going to be worthwhile for you to look at. But many people we see, if they have more of a simple situation, maybe they just have a house, a car, which again can be TOD. They have just retirement accounts where they can just put a beneficiary. They have a bank account, they can put POD. Maybe they don't need the sophistication of a trust. Maybe everything would be good and they can save those thousands of dollars from doing that trust. But for those who have more of a complex situation, well, maybe that's where a trust comes into play. So let's first talk about a type of trust called a revocable living trust. So I'm going to talk about two trusts today, and this is the first one. With a revocable living trust, this is what we see as the most oversold trust out there by attorneys, and it's just a very simple trust. It's kind of a boilerplate template for them to put together, and it sounds really good, but again, you may not need it necessarily, or you could. Okay, so there's definitely some perks of this trust. It's just that it may not apply to everyone. So with this type of trust, basically, you know, when people think trust, they think it avoids probate, and that's absolutely correct. But as I mentioned, you may not need to avoid probate. If you do all your assets the right way and time them the right way, you don't need the trust to avoid probate. So the reason why you would do this type of trust is more so for the creativeness of who's going to get your money, right? And when are they going to get the money? So for example, you could set up a trust where, hey, you leave all the money to the kids in 10 years, or you give them a certain amount each year for the rest of their life if you don't want to give them everything right up front. So you can get more creative on those things. You can make sure that this money stays in your bloodline. If one spouse were to pass away, you know, maybe your child passes away, to ensure it doesn't go to that other, your in-laws basically. A lot of things like that. You can protect it against divorce, and so they can be real creative there. If you feel that is needed, then that's where a trust is definitely that we would recommend you look at. Or if you just have a really complicated situation, more complex, business owner, have a lot of properties, maybe you are very liable to risks, and this could help protect yourself, so that's something to consider as well. But all those could be reasons why you set it up, but again, you may not need it, so you got to make sure you do due diligence for yourself to see what you truly need there. But again, if they're just simply telling you need to do this trust for probate avoidance, you may not need it, is ultimately what I'm telling you. Or if you're looking for more advanced things with this trust, that's where it can make sense. But just what we see is that many people don't get the advanced side of the trust. For most attorneys, they just push it for the probate avoidance, so just be aware of that. The next type of trust we're going to talk about is what's called a Medicaid Asset Protection Trust. And now with a Medicaid Asset Protection Trust, let's first start off by understanding what Medicaid is. So Medicaid is long-term care through the government when you no longer have the money to afford it yourself. And so basically, they spend down all your assets for long-term care, and then when you no longer have any money, the government steps in to give you the type of care that you're looking for no cost, basically. So not too bad, except we don't have any money. And so a way we can plan against that is by this type of trust where we can move our assets into this trust, which removes it from our estate, and that allows us to show that we have no assets, which means that we are eligible for Medicaid, and we still have access to all of our money over here And when we pass away, that money can still go to beneficiaries without having to spend everything down. And so that's where this type of trust comes in. If you're really worried about long-term care, which we see a lot of people are, obviously, 70% chance that someone age 65 or older is going to need long-term care. You probably already know that by knowing a family member or a friend who has needed it. And it's going to last about 2 to 5 years at a cost of about $50,000 to $100,000 a year. So it's going to be very significant over time. And so this could be a way we plan for it, especially knowing that long-term care insurance can be a lot more expensive right now. Maybe you're not eligible for it. And so this can give us more options in that long-term care planning that we're seeing. And so we're seeing some of our clients do this, not all of them again. Not everyone needs a trust, but some of our clients are looking to do this to really protect their assets, to protect against long-term care, and to make sure that money can go to the next generation is ultimately their goal. Just make sure when you look to do a Medicaid protection trust that you work with someone who really knows what they're doing here. Making sure you're working with an elder law attorney is what we'd recommend. Again, that attorney at our office is an elder law attorney for a reason, because that's most of our clients. Most of our clients are 55 to 70 years old, in or near retirement. They're in a different situation than someone who's just starting out. And so because of that, this can make more sense for someone like that. And so you got to understand there's a lot of stipulations here with this trust that I'm not even going to explain about today, because there's a lot of details. For example, this trust is set up as an irrevocable trust. Now, if you know what irrevocable means, that means that you can't change it. And that may be scary, but if you set it up the right way, you can put in clauses and provisions that say that you can still access it and still have access to your money, but it's got to be set up the correct way. So again, working with an expert is going to be extremely important here to ensure you get it done the right way. And again, your goals, what you're concerned about, your asset situation are all going to play a part in deciding if this is right for you or not. And just understand that most law firms, this is going to be the most expensive option that they're going to offer, because it is more sophisticated, which is totally fine. But again, understand that they get the most money from it. So what do you think they're going to push? And hopefully that the law group you're working with is not like that, and you're working with a good firm, which I would imagine you all are. But just be aware of that as a consumer, making sure you've got the educated information that you need to make the right decisions. And so those are the ideas of the trust. So again, it's going to be depend on your situation of what you need and if you do or not. Also understand, I didn't mention for a revocable living trust, if you have a minor child, typically we're always going to recommend that for the most part. So if your kids have kids, maybe you recommend they get that. But maybe if your kids are 18 or older, again, maybe it's not as important to you at this point. So the next thing I want to talk about before we conclude here is just things to watch out for from law firms. So I call it law firm tactics to watch out for. And again, I've already mentioned a few times during this video that you got to be careful with the attorneys you work with. There's some attorneys out there that are fantastic, but we've had examples with our clients where it hasn't always gone the best way. And that's why we've brought that attorney into our office to make sure that our advisors can meet with that attorney and coordinate with the client to make sure that everything gets done the right way. And that's why we feel it's so important to have what we call our 5-pillar approach. And our 5-pillar approach is where we make sure that everything gets done in one house. Tax, healthcare, estate, investment, income. How does everything play together? And so we're not missing anything, because too often we see that you got the attorney over here, you got the CPA over here, you got the advisor over here, and no one's talking to each other. We feel that everyone needs to be communicating the right way, so you're getting the best plan without having you to do all the struggle and having to call everyone and, hey, this person said this and this person said this. But more importantly is we know your situation, we know our client's situation probably almost better than them at some points. And so that's going to allow us to better communicate with the attorney to say, hey, here's what they need. Make sure we're right. Let's confirm that. Let's work together, collaborate to making sure we both have the right picture, because the attorney's going to know their skill set. We're going to know ours. We're going to know the client. That's why we want to collaborate to make sure we don't miss anything. And that's been one of the most values of having the attorney meet with our clients with that advisor in the room is we don't have to worry about the attorney misreading the client or doing something that's not right for him, because we're there to make sure we're protecting the client is the idea. And we've actually had examples. I mean, just recently had a lady who just decided to move forward with us, and she already had an estate plan before she became a client, which is obviously totally fine. But what wasn't great about that is she paid $10,000 to get that trust done. She went to one of the estate dinners there that an estate planning attorney was offering here in town, and they charged her $10,000 to get that done. And she didn't know any different. She didn't know what was the right cost or not. And so obviously she paid it, and it was unfortunate because with her now being a client, she could have got that same type of document done from us for $2,000. And I can tell you that it wasn't 5 times inferior to what she already had done. It was the same type of trust. It's just the difference of working with a team of who's doing the right thing and someone who's just trying to get, basically some money. And so we always want to recommend that your advisor, making sure they work with that attorney. I'm sure that they already have that person that could meet with you there at the office, make sure everything gets done like our setup is. And if not, then maybe you want to, rethink and ask yourself if your advisor's truly doing comprehensive planning for you or not, would be what I would recommend you look into. So back to the list here of the things to make sure you're looking out for. I've already mentioned some of these, but just to summarize it, is pushing that most expensive product out there. Remember, you may not need that most expensive. You need to look at your specific and unique goals to see what you actually need. Using scare tactics is a big one that we see many attorneys use. Hey, you got to avoid probate. Hey, you're going to have a long-term care event. These are the stats. You got to be concerned. You already seen it. Aren't you worried? Trying to push you past comfort, past logic, into emotions is something you really want to be careful of. And if you start to feel yourself getting to that position where you're feeling pushed or you're feeling pressured, that's probably this time you want to step back and really evaluate if this is truly the best thing for you or not, or just get a second opinion, and then making sure that you've got two professionals and you can see and make sure that they're truly doing the right thing for you. One we see often here locally and just all around the country is attorneys offering classes where you get a discounted rate for that trust because you came to that class. Well, that's typically mostly a marketing tactic is what we see, and they're just trying to get you to feel like you're getting a good deal, but really they probably are not discounting their rates that much, and if they are, it's probably very limited. And so just be aware of that you're probably not getting that great of a deal just because you attended their free workshop that they set up to entice you to get a trust, basically. Another one we see often is attorneys will just give you one option and that's it, and they don't try to educate you on the different options that you could potentially have. Remember, everyone's situation is unique. It's not a one-size-fits-all. It's not a cookie-cutter approach. You can get estate planning done in many different ways. It's all about how much do you want to spend and what type of value do you want out of it, right? The more you pay, the more you get. Well, maybe you don't need to pay as much because you don't need as much. So you just need some options to see and help you make an educated, informed decision of what to do is going to be important for you. And the last one we see is just speaking in a confusing way, and this is one that we see with a lot of professionals out there. It doesn't have to be just estate planning, but financial planning and CPAs and taxes and IT, even outside of the professional industry, is people just don't make it simple. Right? So the book I wrote called I Hate Taxes, in that book, I've made it so simple to understand because I wanted, no matter where you are in your walk of life, if you're in or near retirement, I wanted you to get something out of that book. And so it's made for those who are simple and don't know anything. It's made for those who know a lot of things. And that's what we believe. You keep everything at a fourth grade level, especially something this complex that you have not studied every day for your entire life. You need someone that's going to make it really simple, become down to earth with you, and ensure that you know exactly what you're doing, so you can make that educated and informed decision of what you're doing. But if someone's just talking and trying to act smart and you don't understand it, probably need to get a second opinion, probably need to make sure that you take a step back so you can fully understand what you're doing, so you can put in the best position to succeed moving forward. So hopefully you enjoyed this Estate Planning 101 course, and I hope you know exactly what documents you need in place, and this was very helpful for you. Remember, this is general guidance. This is not specific guidance. We would need to know your specific situation to be able to help you further. If you are looking for additional help, feel free to reach out to us. Like I said, we have that attorney here at our office. If you're looking for that comprehensive planning where everything's into one place, feel free to schedule a time with us here. You can go to our website or in the description below if you're watching from YouTube, and we'll be able to schedule a time to see how we can guide you further. So hopefully you enjoyed the video. We'll see you on the next one, and enjoy the rest of your day.
Since we do not know your specific situation, none of this information can serve as tax, legal, insurance, or financial advice and may be outdated or inaccurate. The information comes from sources believed to be reliable but cannot be guaranteed. This content is prepared for educational purposes only. If you need advice, please contact a qualified CPA, attorney, insurance agent, financial advisor, or the appropriate professional for the subject you would like help with. Peak Retirement Planning, Inc. is an Ohio-based registered investment advisor and able to offer advisory services in Ohio and in other states where registered or exempt from registration.